5 minutes late, sure, Joseph. Welcome, everybody. As has become our tradition, once a semester we have a media law speaker at our colloquium. Next year we may up it to 2. We're trying to do a power grab here. Starting with one. Today it's our very great pleasure to have David Levine here. I first heard about David from Woody. I said we want to find someone exciting who's in the area who might be willing to come over and talk to us about legal research. And we said, oh, I know just the person for you. David is an assistant professor of law at Elon University and an affiliate scholar at the Center for Internet and Society at Stanford Law School. His research focuses on the operation of intellectual property law at the intersection of technology and public life, and intellectual property law's impact on public and private transparency and accountability. And what that means for those of you who are just becoming law dogs, it's about access and intellectual property law together, which is a sort of an interesting and unusual topic. David founded and hosts Hearsay Culture, a program on KZSU-FM at Stanford. It's a technology and intellectual property law radio show. You gotta love that. And it's also a podcast. Podcast was chosen as one of the top 5 podcasts by the American Bar Association in 2008. Before David became a law professor, he was a resident fellow in the Center for Internet Society at Stanford. He also has practiced intellectual property, entertainment, labor employment, and commercial litigation as an associate in private firms in Manhattan and as assistant corporation counsel for the city of New York. He has a bachelor's degree in industrial and labor relations from Cornell and a law degree from Case Western Reserve. And thank you very, very much for coming to talk to us today.
Thank you, Kathy, and thanks, Woody, for suggesting me. I'm thrilled to be here, and my effort to make this entertaining may include hopping up on these tables, which Paul put here up front, I guess, for that purpose. To the extent that I can, there we go. So to the extent that he said I can make it more exciting, I'll do that, and I'll just try to look for cues from the audience as we go forward. I'm excited to be here, and it's as I said, a few people I was walking over here. It's just nice to be able to engage the broader North Carolina community that are interested in these issues. I am relatively new to Elon. I started there in the fall of 2009. I taught in Charlotte for a couple of years before that. One of the main reasons why I wanted to move over to Elon was to have the opportunity to get more involved in what's going on in these areas. And so, like I said, thank you very much, Kathy and Woody, for inviting me here. I'm thrilled to be here. The focus of my discussion today is an article that I'm currently circulating to law reviews and going through the ridiculous expedite process to attempt to get it published. It's an article called "The People's Trade Secrets?" And given that this is primarily not a law audience, before I even get into the context of this paper and my concerns with the issue, I think the best thing to do is first define what a trade secret is and why, in a general sense, you as people focusing in communications and media should be interested in it. Trade secrecy broadly is one of the 4 broad areas of intellectual property law. Okay? Copyright, trademark, and patents are the main ones that you tend to hear about. Certainly copyright, I don't have to tell this audience, has gotten a lot of attention primarily for its interaction with media and the entertainment business. Trademark has had a similar profile, although not quite as controversial, dealing with issues like branding and marketing. Patents have gotten a lot of attention, perhaps outside of media, but deal with inventions, right? This podium and how it's built, what this chair is made of, and so forth. And then you have trade secrecy. And trade secrecy is kind of this 4th wing. It's treated that way by scholars, but it is central to our understanding of how we protect ideas and information, okay? How we build those proverbial walls around property in order to therefore theoretically protected from misuse, misappropriation, and so forth. So what is a trade secret? If it's not something that's covered by copyright, like a song, if it's not covered something by trademark, like a logo, if it's not an invention, what is a trade secret? Trade secret is primarily, and this is the standard definition that I want you to think about as we go through this discussion today, is information that is commercially valuable because it is secret. Okay? Now I've summarized a definition which gets a little bit more complex. But if you think about the idea of information having commercial value because it is not generally known, right, or secret, you have an idea of what we're talking about. Customer lists can be trade secrets, although that's controversial. The classic example of a trade secret, the one that you see in all the textbooks, and to the extent you come across trade secrecy in the press, you see it, is the formula for Coca-Cola. The formula for Coca-Cola is held, apparently, in a safe somewhere in Atlanta, has been a trade secret for over 100 years. So it's not patented. It's not patented for a lot of good reasons, including the fact that a patent is public. And information in a patent, after a certain period of time, can be made public. Although it could probably be patented. It is held as a trade secret because it is valuable precisely because it is not well known. Now, two quick side notes to give you an idea about the vulnerability of trade secrecy. The first is a personal one, which is, and this sounds like I'm making it up, but it's a true story. And everything I tell you today, by the way, will be true. So I should put that up front, especially for a media audience. Suppose the lawyers where we might start making things up. I'm kidding. But I'm literally getting my oil changed in Charlotte and reading something about trade secrecy. And the guy next to me looks at what I'm reading and says, oh yeah, I know something about trade secrets. You know that formula for Coca-Cola? I know where it is. And he starts telling me about what bank it's in and how, literally I thought he was going to start telling me the combination of the safe. The idea is that you can lose a trade secret in a lot of very difficult but simple ways. If I have a trade secret in my head, a trade secret of an employer, and I tell you about it, the trade secret's gone. Okay? If you get your hands on a product and reverse engineer it, take it apart, and find a trade secret, your trade secret's gone. Okay? If you independently discover the same information, trade secret gone. So while there are ways to lose it, trade secrecy, unlike the other three major areas of intellectual property, could be held, theoretically, forever. There is no duration built into trade secrecy like there is in patent, in copyright, and to some degree in trademark, although we could debate that point as well. Again, the formula of Coca-Cola is a trade secret. Now, I mentioned the personal anecdote. I'll mention one that I literally just read about this morning. Apparently, according to the Daily Mail in England, a 1979 news story apparently had a photograph that showed the formula for Coca-Cola. This is literally breaking news. And if that's true, and people will figure this out, we could literally see the end of Coca-Cola's formula as a trade secret, which in the trade secret world would be a big deal. So that's what a trade secret is, okay? Think about the formula for Coca-Cola as the paradigm of what a trade secret looks like. Now, what am I talking about with the people's trade secrets? What I'm talking about here is a trade secret that perhaps shouldn't be, that the law allows to exist, but in fact, I argue in this piece, is really not a good use of the law. The people's trade secret is a cute way of talking about a trade secret not only held by governments, but created by governments. Information generated by public entities, or entities that we think should be public, and therefore should have a presumption of transparency, that in fact are being held as trade secrets by governments themselves. Okay? Governments claiming that they own trade secrets. Now, why do we have trade secrets? And this is all by way of background for the non-lawyers in the room. Primarily, we have trade secrecy because of what in IP law is generally known as the utilitarian theory. And the utilitarian theory basically says we, okay, the public, the government, will grant property rights in return for your willingness to create useful articles, to create information, to invent ideas, and whatever else. So you're going to get these certain property rights because the theory is, if you are not given those property rights, you won't have an incentive to create. Why would I create a trade secret if anyone could get their hands on it? I'll never make any money. Okay? That's the theory. Trade secrecy is a weird beast. And it's a weird beast because the utilitarian theory is only one possible basis for its existence. The other primary basis for trade secrecy is what we call, really, unfair competition. How do you lose a trade secret? The main way that you lose a trade secret is literally by someone stealing it, okay? And data bears this out. The primary way that trade secrets disappear is when former employees reveal it to a competitor, okay? So part of why we have trade secrecy is to protect against what we call unfair competition, or within trade secrecy is called misappropriation. Taking information in a way that we don't like, okay? Could be illegal, could be immoral, could be unethical. And so you have two competing doctrines that animate trade secrecy. One theory says you need a trade secret because if you don't have one, you're not going to create. And the other one says, well, we don't want commercial actors acting unfairly towards each other. We need to protect them against bad acts. Okay? These underlying theories are confusing even to IP law scholars. Okay? Trying to figure out why we have trade secrets is a fundamental problem with the doctrine. And it becomes a particularly big problem when governments also use it. Because we have a doctrine, we have an area of law that does not have clear theoretical underpinnings. And when we don't have a clear theory for why we have a law that could be abused. And a government trade secret, or as I call it, the people's trade secrets, are an example of that. That's what I argue. Okay? That's kind of my 10-minute overview of what trade secrets look like. The context of this article is the broad concern that I have about, in my estimation, an increasing use of commercial law doctrines and commercial law concerns by governments to prevent the disclosure of information to the public. Okay? So the tie-in, by the way, if you're looking for the takeaway for you as communications and media people, is that I'm very concerned about how state freedom of information laws operate in the context of trade secrets, and more broadly, how federal law operates. Although you might be surprised to know that federal law, in my estimation, handles this situation far better than state law does, which I'll talk about in a moment. We've seen over the last few years very high-profile examples of governments broadly using commercial law doctrine to keep information from the public that the public has a very strong interest in. I'm going to talk about trade secrets in a moment, because that's the focus of the paper, but to contextualize this, we can start with, for example, the dispersant, or one of the dispersants, used by BP in the Gulf to disperse oil. It's called Corexit. And Corexit is a substance, man-made substance, that has been banned in England because of its detrimental environmental effects. BP, through some subsidiaries, dumped quite a bit of this stuff into the Gulf in an effort, theoretically, to disperse the oil. Why am I talking about it here? Because when requests were made to the Environmental Protection Agency, the Department of Energy, asking for the composition of this dispersant. What is Corexit made of? And not just what is it made of, but what percentages of different chemicals are in it. The government, okay, I'm saying that loosely, but we're talking about agencies at the federal level, took the position that this is a trade secret of the manufacture of Corexit. And therefore, you can't know. Therefore, scientists can't study it. therefore, ultimately, the public can't really independently verify, right, what the impact might be. Obviously, independent, I don't have to tell this on, you can tell me more than I can tell you, independent verification of government information is one of the primary reasons that we have FOIA. And indeed, it's one of the reasons why we have the press generally. Government takes this position. And from a trade secret position, the government's right. It is a trade secret. It's a trade secret of this private entity. If a competitor knows the chemical composition and corrects it, they could use it and perhaps compete with them in a way that could hurt their business and so forth. And that's fine. And that's a strong argument. Where is the public's interest in this scenario? It's not found in trade secret law. And FOIA isn't handling it well. So we don't have the countervailing federal issues and federalism issues of the government's role vis-a-vis its citizens to explain what it's doing and why it's doing it. That's one example. Another example, again, this is all context for this discussion, is the collateral offered by banks to the Federal Reserve through the lending windows that kept them in business. Okay? Literally, several $1 trillion of loans made to banks with collateral that was offered by these banks to obviously underwrite the loans, okay, and protect the public interest, because this is taxpayer money. Same story as Corexit. When requests were made by Bloomberg and by Fox News, and people at Bloomberg, like the late Mark Pittman, who was a legend in making these kinds of requests, when those requests were made to the Fed took the position that this information, that is the collateral, what the collateral looks like, what it is commercially valuable information, and therefore cannot be disclosed. Okay? A variation, by the way, on Exemption 4 to the Federal Freedom of Information Law that deals with trade secrets and a separate category called commercially valuable information, which is related but has some differences. Again, right, from a trade secret perspective, the government's right. If a competitor knows that what the collateral is, or even the fact that a request was made for a loan, a competitor could figure out that maybe this bank's in trouble. On the other hand, do taxpayers have a right to know what the government asked for in collateral in lending several $1 trillion to these banks? I argue yes. And again, trade secrecy does not help us do that analysis, because trade secrecy does not have baked into the doctrine any reference to trade secrets being of public concern. Okay? The last example, notice now I'm not talking about government-created information. I'm talking about information from the outside. So we're talking about the environmental impact of the largest oil spill, right, in the history of the United States. We're talking about the largest bailout of the banking industry in the history of the world, right? Now I'll add in lawmaking. You might say, what is trade secrecy doing in lawmaking? Well, we have, and it's happening right now, negotiations that are ending involving something known as the Anti-Counterfeiting Trade Agreement, or ACTA, okay? ACTA has received some attention, and primarily the attention has come from true IP nerds, okay? Real IP nerds. These are people that, you know, like any community has its nerds. These are people that really, really want to talk about copyright and piracy issues. Theoretically, ACTA is supposed to create an international institution, okay, that will counter or fight piracy on an international level. It's a negotiation among many countries, including the United States, who is negotiating this through the U.S. Trade Representative. For a variety of reasons that would take much more time to explain than we have here, the negotiations of ACTA have been designated an issue of national security. Okay? An issue of national security. And what that means from a legal standpoint is that the Senate can be bypassed. So treaties, traditionally, right, are ratified by the Senate. It's an executive agreement based upon the law. The Senate won't be involved, and the White House, basically, can move this forward and it becomes law. The negotiations of ACTA have been done under veils of secrecy that have not been seen up to now in any
negotiation of anything relating to intellectual property. Drafts of negotiating documents have been leaked, and that's been the main way that people have found out what's going on. Although there have been one or two official drafts released that's come primarily from public pressure. Okay? Where does FOIA fit into this story? Knowledge Ecology International, which you may know of, again, a terrific organization, in my estimation, that pushes on trying to get information from governments involving governmental operations. Jamie Love runs it, made a request to the U.S. Trade Representative, ironically, for documents relating to transparency. Give us documents that tell us what your position is with regard to transparency in the ACTA negotiations. And Mike Geist, who's a professor at the University of Ottawa, has really, and he's done the Lord's work on this stuff, in my view, has spent the last several years really focusing on how bad ACTA has been. Okay? KEI makes a request for documents related to transparency from the government. The government says they can't be released. They can't be released because of national security concerns, and also perhaps because of some commercial information that might be in it. Why? Because commercial entities have had an opportunity to give advice to the United States Trade Representative, where all but knowledge, actually public knowledge, another group, and KEI have not. Public hasn't seen the drafts, other groups haven't seen the drafts, and so forth. Most of the advice has come from the content and entertainment industry. So that's where that's gone. Well, they did release a few documents. Okay, to set up the context of this discussion, one of the documents that was released was a draft of a FAQ involving transparency questions that the USTR would put out. And the title of the email that attached this draft, which was in fact given to KEI as a result of a limited response to the FOIA request, was called Transparency Soup, which I have appropriated as the title of an article that will be coming out in the American University International Law Review called Transparency Soup, ACTA and the Failure of Black Box Lawmaking. Okay, so thank you to the U.S. Trade Representative for putting this phrase together. In the document that was attached to this email, there was a question which had a gallows humor answer to it, certainly if you're a lawyer, but even if you're just a citizen of the country. And the question was, when will the public find out what the U.S. position is on ACTA? And I'm paraphrasing only slightly. The answer, this is a suggested answer in a admittedly draft document, but still a document from the USTR was, the public will find out when ACTA is signed. So in other words, the public will find out what the U.S. position is after this is law. Okay? This is scary stuff. This is scary stuff. Yes, we have lobbying. Yes, we have backdoor deals in Washington and in state capitals. But at some level, you can get information. The USTR's position throughout the ACTA negotiations and this statement has been proven by their efforts to keep information secret, was that the public doesn't need to know what the U.S. negotiating position is, doesn't need to know what this law will look like. They'll find out when it's law. Okay? To me, this is scary stuff. Okay? In the midst of all this, we have government trade secrets, which to me is just a bizarre extension of what I see as an increasing effort to use commercial concerns and commercial law doctrines in the operation of governments, and government both at the state and federal level, in ways that directly impact our right to know. Okay? Let me give an example of a government trade secret now that I've given this context. And again, I'm happy to stop for questions and discussion. I don't mean to give a speech here. And I can talk about solutions as well. The best example that we have so far is a case out of the Pennsylvania State Courts, and it's called Parsons versus the Pennsylvania Higher Education Assistance Agency, or PHEAA, P-H-E-A-A. And you may know PHEAA as one of the entities that administers student loans and competed with, I can't say the late, but certainly the damaged Fannie Mae and other entities like that. PHEAA is an entity that is run by the state of Pennsylvania. The board of PHEAA is made up of elected officials, okay? And in court papers that PHEAA filed in this case, PHEAA said, when these elected officials this 16-person board of FIA, are acting. They're acting as members of the Pennsylvania General Assembly. Okay? So the board is made up entirely of elected officials. What happens? Again, a FOIA situation. A Freedom of Information request is made under Pennsylvania Freedom of Information law to FIA, asking for papers regarding several board meetings that have occurred, retreats and things like that. And so the reporters are looking for a variety of information. The minutes, the receipts, what money was spent, what was discussed, what was talked about, and so forth. Again, this is standard stuff in FOIA, standard things that reporters can or should be doing, right? With all of the flaws that FOIA has that are independent of trade secrecy, right? That's what FOIA is designed to administer. You know where I'm going already, I'm sure, with this story, right? The request is made, FIA responds, FIA says that information are trade secrets. They're trade secrets of FIA. We will not release this information to you because to release it would give a competitive advantage to Fannie Mae and other entities that administer student loans. And again, I would like to see a lot more proof of the veracity of that statement, but as a general matter, that sounds like trade secrets, right? Again, information that is commercially valuable because it's not generally known. Well, this isn't Coca-Cola, right? This is a state entity. Again, a board made up of elected officials. There are questions, right? And you could come up with better questions than I could, that you might want to ask about this data and information that you might want to glean from the data. To whom is FIA marketing? What kind of strategies are they using? Where is the money coming from? Where is it going? And of course, that's general level stuff, but you could also be looking for public corruption. Are there kickbacks, sweetheart deals, and so forth? Okay? So FIA says no to the Freedom of Information request, and the case goes into the Pennsylvania state courts. And the court rendered a decision. This case is a couple of years old now. And after noting that yes, FIA is a public entity, yes, governments are different than private entities, we know what I'm going to say next. The court said, to the extent that there are trade secrets in these documents, they are exempt from disclosure under state freedom of information law. Okay? And to the extent that there aren't trade secrets, go ahead. The court made no mention and really did no analysis of the fact that we're not talking about Coca-Cola. We're not talking about a private entity. We're talking about an instrumentality of the state of Pennsylvania. Okay? That's a problem. And that was it. So FIA goes back, looks for its trade secrets, and that's the end of the case. There are other examples of this arising. It's arisen in the context of, in this case, went to the Ohio Supreme Court, administered public school examination questions. Okay? Questions that were given on state exams, designated by the Board of Education, basically of a city within Cincinnati, within a city within Ohio, as a trade secret, and the Ohio Supreme Court saying, yes, they are. So, the public's ability to test and question whether these tests are doing what they claim to do, as was the request, again, under FOIA, by a number of teachers who wanted to test the veracity of it, trade secret. Okay? Other examples. And stuff gets weirder and weirder. Okay? In Canada, the Royal Canadian Mounted Police, the Mounties, put together a database of firearms. Well, you might say, wait a minute, well, maybe that shouldn't be made public. They're firearms. Well, the firearm database was put together by people that volunteered to help out the Royal Canadian Mounted Police come up with this database. So, members of the public, okay, these weren't security officials or police officers, volunteers. Put the database together, requests are made for it, nope, we're going to sell this to the public, it's a trade secret. Public can't find out. Okay? What prices are paid by the United States Air Force for military ordnance? Trade secret. Why? Because if the prices are made public, bidders could game the system. And even, and this is perhaps my favorite, modifications made to voting machines by a county, not by the private creator, by a county, designated by the government in contracts as trade secrets of the government. The ability, now this had come up previously in North Carolina in the context of Diebold voting machines. But there was a situation where Diebold was saying its own source code, the stuff that it wrote, are trade secrets. And I have a problem with that too. But that isn't even this. Now we're talking about the government buys the voting machine, modifies the machine, and its own modifications are designated as trade secrets. Meaning, to be clear, the public cannot access the source code and whatever other modifications are made to the machines to determine whether our elections are running in an accurate and honest way. Okay? All of these examples are government trade secrets. And all of these situations applying trade secret law as written are non-controversial. Because they all are commercially valuable information because they're not generally known. So where's the problem? The problem is in trade secret law itself. And this article argues that in fact what we need to do is reconsider whether the governments can or should have trade secrets. Now this can be a normative discussion, right? It can be a discussion where we say, well, on one side we have commercial interests, and on the other side we have the public's interest and the right to know. And at a fundamental level, that's what this paper is about. And balancing out those interests is not as simple as it may sound, okay? But there's other theories at play here, right? Theories like deliberative democracy and reason giving, right? Methods that we are trying to move government towards. Certainly the press has been trying to move the government towards this far earlier than lawyers or others have, to force the government to explain its decisions, explain why it's doing what it's doing. Deliberative democracy obviously is undermined where information is not made public. So there's a problem there, okay? Additional problems ensue when we think about why governments have trade secrets themselves and why the government should need a trade secret. Now I get into this in more detail in the paper, but I'm happy to discuss it in questions if you'd like. I'm not convinced that the case has been made that the government needs trade secret protection in order to create. In other words, my argument is the government's going to do what it's doing, regardless of whether it has the right to claim that it's a trade secret, regardless of whether it can say or has the right to say that information shouldn't be made public because it's our trade secrets. Primarily because all of the entities that I'm talking about are under mandates. They're under mandates to do what they have to do, and that comes from law. So I'm not convinced that governments necessarily need trade secret protection, nor am I convinced that even if there is a need for it, that it outweighs the public's right to know, given the gravity of the information that we're talking about. Okay? So that's another reason why I'm concerned. And I can talk about more of those reasons, but let me skip now to solutions, and I want to make sure that I'm staying generally at the time, and I think I am. There are three primary solutions that we could come up with here. The first is to say, there's no such thing as a government trade secret. Simple, end of story. You do that in trade secret law. So trade secret law, not freedom of information law. Trade secret law says the government can't have a trade secret, that's it. The second solution to this problem, the second solution actually comes from the federal freedom of information law. Because actually here, federal law is much better than state law. All the situations that I've talked about here, right, all the examples I gave of government trade secrets, come out of state law. The reason why is that federal law actually has written government out of the trade secret exemption, for reasons that I don't need to get into. So another solution is to amend FOIA. And you amend FOIA to say the government can't have a trade secret. And the last solution, which is an interesting one, is to narrow the definition of a trade secret for purposes of government. So in other words, raise the bar on establishing a trade secret for governments under the theory that if they really need the information and they meet that standard, we'll be comfortable with the impact on disclosure. Having gone through the analysis of the paper, which is on SSRN if you want to read it, I ultimately conclude that I'm not really satisfied with those latter two solutions. That because trade secrecy was not designed at its fundamental level to deal with issues of public concern, because it was not written with governments in mind, and that's established, not only through the cases, but through model laws that exist, the primary one being the Uniform Trade Secret Act, which doesn't discuss this issue at all, and some other reasons. Ultimately, I say the best solution is to write governments out of trade secret law. I certainly know that the case hasn't been made that the impact would be great on governments. Even if the case were made, I'm highly skeptical that it would outweigh the public's right, ultimately, an interest in knowing the kind of information that's been held back. So, I skipped a lot of the analysis and a lot of conclusions to open up for discussion, but I'm happy to discuss any of it. But that's this piece. The longer term, the last thing I'll say, is where is this headed? Well, like I said, this paper is going through the process of publication or being accepted for publication. The next project really takes this idea and goes a step further to say, are freedom of information laws and are our freedom of information laws accurately reflecting our capabilities and technology to use information? And so the next project is kind of a jumping off point from here to look at ways that we might use network layering and technology to alter what freedom of information laws mean. In other words, we're not as interested in 2011 in your documents. We want to see your data. Keep your conclusions, keep your ideas. We're not as interested in that. Give us the data, right, that led to that conclusion, and we'll do our own analysis, right? The public, right, can analyze this data in ways that might lead to, right, and the reason why governments would want to reveal this information, uncomplimentary, right, analyses or conclusions that the government wouldn't reach. Freedom of information laws, in my estimation, do not reflect the kind of technological capabilities we have today. They talk much more about documents and less about data and information. So that's where this is going next. I'm happy to kick that around. That is in its very early stages, so I certainly would welcome comments on it. But that's my talk on government trade secrets. I'm happy to have discussion.
Thank you. Let me just say, don't tell a lot of government officials about this.
Yeah.
Because they probably haven't thought of it yet. But when they think of it, or they hear about it from you, they think this is really a great idea to hide government information behind trade secrets. I'll go ahead, since I can, I'll ask the first question. Are there any state public records laws that either define trade secrets to exclude the government, or where they're talking about changing the laws to do that?
The short answer is I've not seen many. There are one or two states that I think primarily because they grabbed language verbatim from federal law, happen to have it in there. Connecticut, interestingly, is litigating this issue right now, involving an administrative law decision where an administrative law judge said the University of Connecticut can't have a trade secret for a lot of the reasons that I mentioned. So that's winding its way. It's now at the appellate level in Connecticut. But with the exception of one or two states that, like I said, kind of alluded to your initial comment, by mistake, really have this in there, the rest of the states, it either hasn't arisen or it hasn't gotten to the point where it's litigated, or I haven't seen it in the law.
Yeah, because generally those definitions in the laws of what constitutes a trade secret have been around for a long time.
That's right, yeah.
And they could accidentally say it has to be about the secret of a private commercial entity.
That's right, yeah. And I'll tell you, from my previous experience as a litigator and thinking about this exemption, your point is very well taken. Working for the city, I wasn't a freedom of information officer, but in litigation, you make a lot of decisions that are similar. There are certain duties in discovery that require you to put in information you wouldn't want to otherwise. But there's similar decisions in terms of what we really need to disclose and what we have to disclose. And I'll tell you that, to me, if the government is using the trade secret exemption to disclosure, it's their last-ditch effort, right? Because there are other exemptions that are far less controversial. They're controversial in their application, but in terms of saying we shouldn't have a national security exemption, right, in the freedom of information laws, well, you might say, right, it shouldn't be abused, but you're not going to say it shouldn't be there. And so you go down to deliberative process privilege, and these other privileges that go towards fundamental government operations are less controversial. When you get to trade secrets, my view is you've already decided that none of the other exemptions are going to work, and that now this is your last shot at trying to get it out, which is perhaps part of the reason why we haven't seen much of it. Although I expect to see a lot more of it as governments more and more play a commercial role and engage in public-private partnerships or outsourcing and so forth.
I'm thinking about what we were talking about today about the city-owned and operated broadband systems in North Carolina fighting with Time Warner. And they may have incentive not to want to give up their information about the economics of that, because then the economics aren't that good. And
Right.
so it might put
That's really
disadvantage them in the legislature when they're trying to legislate this.
No, that is a great observation. I had talked about that in a piece that was in a Florida law review a few years ago on public infrastructure and trade secrecy, where cities at that point, and even earlier, were trying to figure out how to create municipal Wi-Fi. And the same issues arose. Now, there's great literature, really interesting stuff, written by people like Brett Frischman and Mike Madison and a few other people who have talked about public infrastructure, and that Wi-Fi is a form, or should be viewed as a form of public infrastructure and subject to different rules. So a lot of this came up when I was at Stanford in San Francisco, where Google...
Different rules meaning that it can be a trade secret?
Well, different rules meaning that we shouldn't treat municipal Wi-Fi, for example, as just like any other infrastructure because of its ultimately its pervasiveness and the need for the public to access it generally. It's not just about sharing information. In San Francisco, certainly, it was about being able to call the police. So, I mean, it gets to a fundamental role of government type analysis. And the same issues arose. Earthlink and others bid on the process, right? Bid on offering this infrastructure and say, well, you know, we may not do this if our information is made public. Again, I'm never convinced that that's really true. It's said, it's alleged regularly. But in the case of North Carolina and Diebold, right? Diebold is supposed to offer its source code under North Carolina law. Diebold says we can't offer the source code on our voting machines because they're trade secrets, probably at Microsoft, but they didn't actually say. So we can't bid. And after a long, drawn-out battle, including where North Carolina actually said, that's all right, don't tell us the source code and we'll approve you anyway. And it took some litigation to get the state to say, no, you can't, to get the state back off from that. Diebold left, and someone else showed up, another vendor, to sell the same similar voting machines, and they offered the source code. So one vendor doesn't come in, another one does. We could argue about whether is one voting machine better than the other. Well, I don't know, Diebold certainly doesn't have a great track record on voting machines, so I might go with others before I go with them anyway. So yeah, this is a big issue.
The FOIA and North Carolina's public records law have those categorical exemptions. So the question is always, does this particular record or piece of information fit within the definition of this categorical exemption? But then some states like Florida have a different exemption scheme where the legislature is required to enact a specific exemption for each document or each piece of information that's going to be exempt. It's under that. Everything's open unless it's specifically exempted. So that trade secret issue wouldn't come up necessarily in that realm, would it?
It may not. Federal law writes governments out of the equation by saying that governments aren't people, right? They aren't a person. And because they're not a person, then the trade secret exemption doesn't apply to it. You know, North Carolina's got, I recently, last year, I looked at it pretty closely for an open government forum that we were doing in Greensboro through Elon at the Sunshine Center. And North Carolina has quite a few very specific, as you know, exemptions written for industries. And so, the way that it has come up, and again, this issue hasn't come up much. The irony is that the only way to really find out how prevalent government trade secrets are is by sending FOIA requests, just as KEI did, right? The USTR sent my FOIA request would be, tell me what trade secrets you have, which of course would then immediately be objected to. So we'd have to find another way around it, but that's the idea. We don't really know, right, how often governments would even think of alleging trade secrecy. Although again, I do think that, especially this Connecticut case winds up being a successful use of it, we could see more of it. Yeah, I mean, it arises in a different context, because in one sense, at the federal level, you have very limited, you have broad exemptions, but only a few listed, right? Like six, 8 or 9, I guess, about 9. Whereas you have, at state level, sometimes dozens. So how it arises...
Well, or in Florida, you've got hundreds and
hundreds, right.
Because each individual, you can't raise a general privacy, exemption to some document. That document's got to be exempt. So, for example, recently I think there's some new legislation now that protects autopsy reports, because that was, the legislature is required to enact a specific exemption for each requested document. So I'm thinking, that could be some kind of a fourth solution.
Yeah,
and I don't know how this comes up in those kinds of states like Florida.
Yeah, it's a good question. I should look at the Florida statute more closely. I'm confident in saying that I'm aware, or I have not. If there is a reported decision involving a government trade secret, I'm confident in saying that I've seen it. I've spent a few years looking at this, and so I feel, as certain as one could be in research, I feel good about that. This issue, interestingly, of course, was of interest to Florida generally in the wake of, 2000 election, hanging chads and everything else. But I need to take a closer look. I think that is a fourth solution, potentially along the lines of the carve-out that I talked about. I'm dubious on solving this problem through FOIA, because at a fundamental level, I don't think the government should have trade secrets anyway. I don't think that trade secret law itself supports it. So, and that gets into some other issues, which I'll mention very, very briefly. But trade secrecy itself, as conceived, right, consistently involves, in the paradigm litigation, involves, as I mentioned at the beginning, employee leaves company and takes trade secrets with her, and then reveals that information to a competitor. Okay? That's your classic trade secret misappropriation claim. As confident as I am in saying that I think I've seen every time or every case where the government's raised a trade secret, I'm also confident in saying to you that I've never seen, and I'm not aware of, the government ever bringing a trade secret misappropriation claim against a former employee. And that's the paradigm. If you open up an IP textbook, you're not going to see discussion of this issue, although I've suggested it should be there. But it's not the focus of trade secrecy. Trade secrecy was not built to be an exemption to freedom of information laws, right? It fits very neatly into how private entities use trade secrecy, because they use it primarily to prevent the disclosure of information in scenarios that we would generally agree are bad. People shouldn't steal information, right? People shouldn't sign a contract saying they won't reveal information and then reveal it. Those are the paradigms. The paradigm trade secret case is not the government has information and a freedom of information request comes in and the government says it's a trade secret, right? Especially where the government hasn't made the case, and I don't think they have in any of the scenarios that I've mentioned, that they would not have created the information if they had known that they wouldn't have trade secret protection. Now, if I see one case where the government brings a misappropriation claim, which is bizarre as I say it, every time I say it, I think, how would that work? But if I saw that, I might start thinking maybe there's more to look at. But in the absence of any precedent, I mean none, where the government used trade secrecy in its primary purpose to prevent misappropriation through a misappropriation allegation, I'm not willing to merely say solve it with FOIA. You solve it on the front end so that we never have to litigate the issue. And I prefer, my own bias, that reporters have fewer barriers to information and the public, right, than more. And so to the extent that I can cut down litigation under FOIA, I prefer to do it. And if you carve it out of trade secrecy, so that governments don't have trade secrets, or the government can have a trade secret, however you put it, you leave FOIA as it is.
So, to what extent can the government deny access based on the other categories of intellectual property that you talked about?
That's a good question.
I'm trying to think about that. Like
Yeah.
if they're saying, okay, this we're not going to give you because it's a trade secret, does the government have a patent? Does it have a trademark? Does it have copyright?
So the short answer is the other doctrines are not, generally the answer is no, they're not exemptions. The way that it works, first of all, a patent is made public, okay? So once you file, when you file a patent, when you put in a patent application, after a certain period of time, that's made public. But once a patent issues, that's a public document, okay? So by inherently, you can't use patents, you can't say it's a patent and therefore it's secret, it shouldn't be disclosed. Copyright is kind of a weird area because in many, certainly on the federal level, the government can't own copyrights, right? So the government can't say, for obvious reasons, that the law is copyright protected. Although there's some weird cases there too. There's some really interesting cases where municipal codes, like building codes, have been written by private entities. Okay, I mean, in Washington, we call them lobbyists, right? And certainly, state capitals call them lobbyists. Frankly, at the local level, I think we call them lobbyists too. But a private entity writes a law, the government passes it, and then when another government, okay, wants to copy that law, which is standard practice, and in a lot of ways how government should work. Something's working in one place, let's use it somewhere else. The private entity that wrote the law says we have a copyright over it. So even though it's law, because they wrote it, they claim copyright. Those are some interesting cases that actually have got a little better for the private entities than I would have liked. But as a general matter, copyright doesn't play a role. Trademarks is interesting because a mark in and of itself, to be valuable, is made public, right? So I mean, the fact that you mark something, I mean, it doesn't have as much value, or really any value, because the whole purpose of trademark law is to designate sources of origin, right? And so it doesn't play the same role. But more broadly, IP and IP concepts are, in my opinion, this is really the longest term project. These ideas coming out of IP are more and more infiltrating in places where they shouldn't be. Ideally, 10 years from now, I will have written the book on the role of secrecy through IP law. And so IP law, okay, has, again, baked into it, which is such an academic phrase, but I'll use it anyway. I only heard it when I started going to conferences, so, but I'll use it here, what the heck. Baked into it, these ideas of secrecy that come up in subtle ways.
Are any of the cases that you've looked at, do they involve universities? Because I'm just sitting here thinking about universities, competing with one another for graduate students, competing with one another for essays. I mean, and federal money. I mean, there's so many types of competition amongst universities, from public and private. It seems like an area that's ripe for.
Yes, the case out of Connecticut involves the University of Connecticut and a list of donors. But again, just to be absolutely clear, the examples I'm using are almost all actual cases or allegations made. That's different than something other than litigation. So there are more and more stories that I read. Again, I say more and more as opposed to one or two a year, maybe 6 or 7, that I see in the same time period, where universities are claiming trade secrecy or commercially, some kind of commercially valuable information over donor lists, there's an interesting one, comparatively silly, based upon the information I talked about the other examples, where if I remember this correctly, the student union for Ohio State claimed that it could not reveal, for commercial reasons, what it paid the band Kings of Leon to perform on campus. Okay, and but that hasn't been litigated. So the claim is made, and again, how does this come up? Right, the FOIA request is made by an entity of the press, and then when it's denied, there's an article about the denial. So that came out of actually the student newspaper. So more and more it is coming up. And that's where, again, I presented the case against it. There's a real challenge, however, because the reality is, right, this would be an easy case if it weren't for the fact that governments are competing. And they are competing not only in the private sector, but as you point out, they're competing with other governments, okay? Having said all that and acknowledging it, until governments make the case that they need these walls, my general bias is to not give them. And I treat that in IP generally. You know, we make a lot of assumptions in intellectual property law about the rights that we need to grant creators. And I'm all for them when the case can be made. Okay, and much of trade secrecy is uncontroversial about that. Okay, so I'm not, you know, sometimes when I talk about this, I get a pushback that says, well, you're just against trade secrets. Not so. I have zero problem with Coca-Cola having a trade secret in its formula, none whatsoever. Okay, now, if there was some evidence that Coca-Cola could kill you, as there is some evidence growing about carbonated beverages, well, maybe I'd like to see a little more disclosure. But that, even then, I wouldn't say Coca-Cola should have a trade secret. The kind of interaction that I'm more concerned about in this paper is where governments create the information. And in the previous article, which was published in the Florida Law Review, I talked about public infrastructure providers. You know, so creating a voting machine, a core instrumentality of government, to me, should be treated a little bit differently than the formula for Coca-Cola, even though private entities create both. But that's the real challenge, is what you do with the fact that governments are in fact competing.
When you were talking about the classic case of the employee leaving, you know, and revealing secrets, I mean, you know, we're all used to a faculty member who's got his or her lab set up here and graduate students and federal grants, et cetera, and then gets moved away by another university, taking with the individual, the graduate students, the grant, you know, the whole shebang. That seemed to me like a classic situation in which asking for some university to somehow, you know, use a trade secret kind of play.
No, that's a great point as well. You know, and again, you know, that's something I've thought about a lot. I mean, the two quick reactions to this: first, again, we haven't seen litigation around it. But secondly, the Bayh-Dole Act, right? A federal law that has exploded patents in primarily research universities, right? Where you have the ability of state entities, right? Of public entities to patent their inventions through the Bayh-Dole Act, right? Through this act that allowed for commercialization and really for moving all this research off the shelf from universities and into the market, where theoretically we could have a good. Interesting reality there is that Bayh-Dole doesn't allow for trade secrecy. And I've written an article about this that's coming out in the Hamlin Law Review, where I point out that you cannot have a trade secret through Bayh-Dole. The only option you have in Bayh-Dole is to patent it. And by the way, someone has to. So if the government doesn't do it, then the private entity who's involved in the research can. But Bayh-Dole excludes trade secrecy as an option. And I went through the legislative history to get to this idea. And of course, not surprisingly, there weren't a lot of debates about whether trade secrecy was involved, but there was discussion of secrecy generally. You had several major sponsors, including Senator Bayh and Senator Dole, talking about the concern that we should not allow secrets to exist in research at universities. And we shouldn't allow private entities involved in that research to keep secrets. Limited discussion of trade secrecy, that broad idea was there. And so Bayh-Dole's been very successful. In fact, depending on your perspective, too successful, right? Turning universities into commercial entities and so forth. So there's an example where, even in those situations, the case is not made that governments need a trade secret, at least to me. I just saw your hand and then Paul.
I was just wondering if you were concerned about the collateral effects of getting rid of governmental trade secrets. So maybe governments don't need trade secrets, but let's take it for a tried example, the Keynes and Leon case. Let's say Keynes and Leon gave a discounted rate because it was students, but they don't want that discounted rate getting out. Are you
almost sure that was what was
right? Exactly.
But I don't think they just decided not to give it out. I think Keynes and Leon's management.
Well, I'm sure. So I guess my question is: are you concerned that this would have a discouraging effect on a lot of people on entering into any kind of agreements or deals with the government because they know there are certain things of theirs that might become public?
Right. So no, that's a great observation. Also, that is really the fundamental challenge to this suggestion. To the extent that we might have disincentives for private entities to provide government services, right, or provide the best form of that service, right? Well, since we're not going to lose a trade secret, let's offer something less than what we can optimally offer. I think that's a legitimate concern. My response, really, okay, my response ultimately is this. That's the trade-off for transparency, right? I mean, there's a choice, right? The choice for Kings of Leon is one that the market requires providers to make regardless, right? Whether they're Kings of Leon, right, or Diebold, right? You want to serve this market, okay? You want to provide whatever you're going to provide to that market. There's a price. And the price with regard to government is we're going to have to know a bit more. Now keep in mind again, I'm only talking about trade secrets, right? Now, Kings of Leon wouldn't have a national security, I hope, wouldn't have a national security. Or they do, then there's been even more outsourcing of military behaviors than I thought the government was doing with Blackwater or XE or whatever they're called now. But if there was another exemption that might apply, again, I'm not taking issue with that. You know, so I'm not challenging, although there's reasons to challenge some of the other designations. My quarrel is with trade secrecy. But that would be the price. And again, to the extent that this issue has arisen, where we could actually test the scenario where trade secrets might be lost, North Carolina being an example, other vendors have shown up who are willing to comply with the law. Okay, so let's say, I don't know, Kings of Leon's a tough one. What would be a slightly worse ban than Kings of Leon? To me, I don't know, string cheese incident? I don't know. So if we come up with another ban, slightly worse maybe, but you know, that's the price.
So I have two parts to this. One is the claim that Vidal was a success, which if you measure patents filed, yes. If you measure money returned to the patent to the people who filed, no. And there's a lot of analysis on that. In fact, in Winkler's book, there's a pretty good chart that shows it actually didn't return much money to the universities. And here we are at the home of engines of innovation, and even Holden says it's screwed up on NPR yesterday. So so my quarrel is that that part is Vidal is in fact not a success, and in fact just they're filing unnecessary patents, which even shows it's worse than not a success. It's a failure because it replaced patent filing with transfer of knowledge. So whether it's because the universities aren't very good at it, Holden's claim, or that just private entities sitting on the edge happen to be better at converting, and the university will never be good at it, probably my claim. And possibly because it's not a business. The second is what they were talking about when they were talking about secrets. I have been fairly certain, and this is like the Kings of Leon guess, the Woodies, that they're really talking about defense secrets and stuff, and how to use the baked-in example. Some things need to be secret because we might want to use them in defense or some other ways later. And Dole, my guess is that Dole had more of that in mind than trade secret. So you're probably safe in that trade secrets probably wasn't even part of the discussion. I mean, because the government's paying for something to be created and ripple out to the economy anyway. The exemption, and as you said, somebody has to patent it, or if not, it just goes out. Anyway, you're supposed to publish it. Or you don't get further support. So the incentive, the government incentive is to bring, it is a creative incentive. We give you this money to create this work. Too many professors are leaving and starting their own companies and not revealing. That was the Vidal's origin was professors weren't publishing stuff that they thought they could make a company out of later. So the theory behind it was all these guys that are doing drug discovery or NSF stuff, they're not publishing all their work. And we just paid to have all that work published. They're really hiding it, putting the university starting a business. The university should be a player in this. I mean, this is the theory, this is the rhetoric of Dole and Val on this. And the way we'll do that is we'll let them do the patent instead of putting it in the public domain. And so instead of having SAS, totally independent, just to pick somebody who was jump-started by government money that any at random that happens to be nearby, got Department of Agriculture money, built their software, free by dole, government, all public domain, they walk off and create a business. Now, they didn't do it, maybe, because it would have been illegal, by hiding work that they did on the side during that period, and I would never accuse Jim Goodnight of doing anything shoddy or evil or undercovers, despite his personal life. But that's a prime example of North Carolina State should have probably had a stake in that, probably.
Yeah,
And probably it all should have been. So North Carolina State should probably have part of SAS.
You know, I appreciate those comments. Well, let me be a little more clear on my reference to Bayh-Dole, because the purpose of the article was written to get, really for me, to get at this argument that we need trade secrets.
Right.
And so, all of your points about
I think they
Bayh-Dole-
support you.
Yeah, right. And so the issue, right, and so the issue with Bayh-Dole, for my purposes, right, is to show a situation where, again, if the fundamental reason for having trade secrecy, right, is to move, in the case of Bayh-Dole, again, is to move these products into the market, right? With the secondary concern being how much revenue is actually generated, right, by universities or private entities.
And they have some startup money they should get.
Right. That Bayh-Dole proves that there can be, right, in terms of sheer numbers, regardless of how it's split, right? So that's where that was going. But I think that's a great point.
Yeah, I think they're just two different measures for that.
Yeah.
So one is does it move into the market, but the other is does a product
Right.
the act actually come into excellence.
Yeah.
I've got to run the class, so.
Okay, two more questions, Michael.
Okay. Quick question. This is an issue that came up a couple of weeks ago. We were having a different discussion with a different group. And this School of Journalism is operating now an online news organization. And these operations are in place in a number of journalism schools around the country, some of which are at state universities. And the question came up about the extent to which this news operation operated here in the School of Journalism at UNC Chapel Hill, which of course is a state university, is subject to open public records, public meetings laws, those kinds of things. So it seems to me that you've got a news organization that may have to operate under a completely different paradigm than an independent, privately operated news organization, meaning a news organization that's subject to mandatory transparency under open records, open meetings laws, those kinds of things, and can't argue trade secrets if a request for information is made by, say, a competitor like the independent Daily Target. I don't know what trade secrets our operation might have, but what's your thoughts on that?
On the role of a, just to be clear, on the role of a news gathering entity operating in a state institution.
Right.
Yeah. So
that may be actually operating as a news organization, not as a public relations arm of the school or the university, but as a news operation that may well be competing with other independently operated private media organizations in the same market.
That's a really interesting example. I mean, because it goes to, so first of all, I mean, again, any entity can have a trade secret. So I mean, just to put that on the table. So there still may be trade secrets within news gathering, paradigms. I mean, we've got a lot of ways that could go. Of course, what you're talking about, right, is something that would be relatively unique, perhaps, to news gathering organizations. That is, for example, a source, right? We wouldn't want to say that, if a news gathering entity, it's an interest. I mean, it's what I really haven't thought about as much. I'm glad you raised it. So if a news gathering entity, right, has a source of information, and let's say, I don't know, Bradley Manning, right, who may or may not be the source. I guess we'll find out at some level. We wouldn't want to say that entity would have to reveal it because it shouldn't have a trade secret. And so, tell me if I'm not going in the direction that you're asking. So my reaction to it is twofold. First, yes, that entity may be able to get under the law, have a trade secret, but now you're talking about really the primary objection that I have to trade secrecy existing in governments anyway, right? Which is broadly, right, the ability for the public to gather information. If it is in fact a news gathering entity, okay, at a state level, who can, again, and this is key, can prove, right, to the extent that there's a trade secret need, it needs it for purposes of gathering information, then I might, I'd have to think about that more. And I might say that because, again, a lot of what I'm saying is a normative judgment, right? It's a normative judgment of whether it's more important that the public have the information versus the need for the trade secret, that this may be your classic circular scenario where your argument for having a trade secret is primarily because you want to provide information. So it's an interesting challenge. Now,
But maybe it's not a trade secret.
but maybe, but that's what I'm saying.
Yeah.
Assuming that trade secret's raised. Right, exactly. No, assuming that trade secret's raised. I mean, there are other well-established, right, exceptions for news gathering organizations on issues like what I just raised.
There might be a shield statute.
There might be a shield statute, and you have cases, obviously cases like the Pentagon Papers and whatever comes out of the WikiLeaks situation, right, which will establish this perhaps certainly Pentagon Papers at the constitutional level. So there'll be other protections. But with regard to the relatively narrow question of a trade secret, yeah, I mean, that would be an example of something where I'd have to think more carefully, but I think I could still fit it into the scheme that I'm talking about because I don't see the proof of the need to have the trade secret. So I guess that's my reaction. It's something, thanks for raising that.
Thank
Yeah, it seems like in light of what you're saying, wouldn't applying trade secret language to that mean that you're saying there's a competitive disadvantage to the news organization vis-a-vis other news organizations, not that the information would dry up because of the source.
Right.
And so, on the one hand, information drying up because the source is made public, that's like sort of like shield statute, that kind of question, is bad in general for transparency and disclosure of information. On the other hand, it's not necessarily in the public's interest for one organization to release this information as another. So it's not a competitive, the language of competition that's in the trade secret legislation seems like it wouldn't apply here, right? It's not for competitive reasons that you'd want to, or maybe you want to retain the source for competitive reasons, but I don't think.
Yeah, I mean, I assume that my answer that the definition would be met, and then what would we do with it? But it would be it would again, when I mentioned earlier that trade secrecy would be the last exemption that I try to use if I'm trying to keep information from the public. I also suspect, again, because of how well established these kinds of protections are, particularly for news gathering organizations, right, that you wouldn't necessarily get to a trade secret. But if you did, and again, imagining what I think is the really interesting point that I took from what you said, if it got to the point where trade secrecy was the only basis to protect information that goes towards direct, and I would want to say directly, right, not indirectly or not possibly, but directly towards the ability to gather information that would then be made public. Now, I might say, well, Matt, that's a classic hypothetical in a law school, class, where you throw out the one situation. I might say, well, you're now getting to the problem. So maybe we'd have to think about that.
All right. Thank you very much.
Thank you. Thank you.
You were talking great like we are.
Right.
So that was really very provocative.
Yeah, I thought.